Good.
Yeah.
I had you on Zoom, so good to see you in person.
Yeah, happy to be here in person.
Well, let me just start off here. Good morning. It's Friday, March 2nd, 9 a.m. A few minutes after.
May 2nd.
May 2nd. I apologize.
That's okay.
What I said?
March was fun too.
March 2nd. Oh yeah, I think we don't want to go back. May 2nd, 9 a.m. A few minutes after. We're going to talk with Peter Gill, Executive Director, Land Use Review Board. And what we're talking about for folks that might be tuning in is that we've been we're talking about accessory dwellings and a situation in Barnard. We're trying to figure out fact and fiction, and if there's any resolution or anything, just trying to get some clarity as far as where we're at. And so we figured that we would have Mr. Gill come in and tell us what he knows. And welcome, and the floor is yours, sir.
Hey, good morning. Again, Pete Gill, Executive Director for the newly formed Land Use Review Board, Ministers Act 250. I'll start with a couple of disappointing things for you all, but then I'll get to some other exciting things too. First is, I know there's some interest in this committee on some active investigations, and I can't get into specifics about those right now and today, but I am, on the good side, I'm very happy to give you kind of some overviews in terms of the enforcement process, how that works on our side, and also specific legislation. I know you guys are working on some legislation. Love to dig into some of that as well, but the board is kind of taking a stance in terms of policy bills that are going right now. They've got a lot on their plate. I'm going to go through a little bit of that, and they're working on just implementing Act 181 and moving that forward right now. And so they're taking a little bit more of a hands-off approach in terms of active policy legislation that's out there. So I won't get into a lot of details on that. But again, I'm happy to talk through kind of the enforcement process and kind of where we are as a board, give you guys a little bit of overview that way. I don't always get to get into agricultural committees, given that Act 250 does not apply to farming. There's an exemption for that. And so we'll get into a little bit more of that, but wanted to give you that kind of background there. And then as a teaser, I've got a quick little quiz for you at the very end. So we'll go with that. So what is Act 250? It's a statewide permitting system. I'm not going to go through all the details here, but I will certainly follow up with the committee with these slides that you have them. It depends on the size and the acreage of the parcel and the use type that it's being used. But where there's a commercial development, of course, farming is a commercial operation, but the legislature has, as you see there, explicitly said from the beginning there is no permit required for farming, as that's been defined. But where there's operations that are commercial, whether they're on farms or otherwise, and they meet kind of these requirements here, that's where Act 250 gets involved. And then the next step there is for permitting to occur after that. And when permitting occurs, there's volunteer appointed members of district commissions. They're all oriented throughout the state. I think I've got a map slide on that, maybe not. So at any rate, I'll go back here for a second. The different districts, there's commissioners that are appointed in those districts. They take in those application materials from a permittee, somebody or an applicant that wants to build project X, Y, or Z on a commercial scale, and they review that for a whole host of different criteria. One that might be of interest to this particular committee is agricultural soils. So to make sure that as a state, we're looking at those agricultural soils and making sure that they are protected or accounted for in one way or the other. There's offsite and on-site mitigation, as you may be aware of. I won't get into more detail on that now, but just so you're aware of kind of the things that the district commissions are looking for when they are permitting projects. So just as an overview, kind of permitting by the numbers here, there's a lot of things that get thrown around about the overall process of Act 250. Generally from 350 to 400 different permits are issued throughout the year. Only about 5% of those actually go to a hearing where there's where there's contested matters in the issue. The others are done through administrative processes or through a minor permitting process, where there's a notice period for proposed permit, and then it's issued within a very short time after that. And 0.2% are denied. So that's roughly, 1.5 per year, plus or minus. And then in terms of number of decisions that are appealed, that is also fairly low, 1 to 3% of decisions are appealed. And that's on the permitting side. It's about the same on the jurisdictional side. So there's also a process, get into too much of that, but determining, does jurisdiction apply? Does this project meet those different categories that we talked about in the first slide there? And those, again, it's about 5 to 10 per year that are appealed, of 270 jurisdictional opinions that are issued. Does Act 250 apply or does it not? So a lot's been happening since Act 181 that was passed by the legislature last year. There was kind of 3 major categories that occurred in that process. There was governance, there was jurisdiction, and there was an additional criteria, review criteria. So we have 32. This would make it 33 criteria that those district commissions would be reviewing applications there. Governance was a big change. We have now, instead of 1 full-time chair, we have 5 board members who are all full-time members of the board and active staff in the process, which has been a little bit of a change in terms of our overall governance. And they've got a lot of duties, as I was saying. Right now, they're setting up the review process for future land use maps, land use plans, the Tier 1A and Tier 1B areas. So those are areas that will have different levels of exemption from Act 250 within more populated areas. They are going to be approving the designation program areas. So where incentive programs are applied in the state. And then they've got a host of rules and rulemaking activities. And one that I've highlighted here is the wood products manufacturers. I know that's been important to the agricultural community and the house agriculture as well. That wood products manufacturers study has gotten pushed back a little bit in terms of its timeline, as you're aware. And we're looking at about, I think, June, it's either 15th or 30th, in terms of having a completed report. And we'll make sure that this committee gets a copy on that. That the overview of that report and what we're looking at there is the minor process working for certain wood product manufacturers, and how can we better support that sector. Jurisdiction, changes there were also very large. We went through the first slide, kind of the standard Act 250, where does jurisdiction apply, depending on your acreage and your size of the parcel and property. Here, now we're looking more at location based, right? We're talking about those Tier 1 areas. We're talking about Tier 3 areas, those conservation sensitive ecological areas, and saying, okay, how is that going to be mapped? That's an active process that's ongoing. And as I said, the board will be reviewing those plans that are submitted from the regional planning commissions. Review criteria, as I said, one additional criteria being added. Here's the map that I was searching for before. Just shows the various districts. The Land Use Review Board oversees all of that. Kind of two operations now, right? There's the permitting side of our house, and then there's the mapping and organization of overall land use development here under the board's jurisdiction now. As you can see here, 9 different districts throughout the state, mostly on county lines, a few anomalies there as well. We've got district commissioners that I talked about. They're the ones making those decisions on permitting. we've got the land use review board, the overseers and the approvers of the land use maps and plans. And then you have the district coordinators. Those are the individuals on our team that are shuttling permits through the process and helping to have people understand when jurisdiction applies on their property and when it doesn't. So they're there as a helpful individual for that process. Here's kind of an overview of the new framework. Shows on the bottom line there for Act 250, you can see the different tiers, full exemptions under 1A areas, 1B areas, partial exemptions for focused at housing developments, and then kind of the status quo to tier 2 areas, which will be reviewed by the board in a report in the coming year, and then tier 3 areas. I'll just note here, these are not shown as, geographic representations of size or anything like that, just a schematic here. And just moving into accessory on-farm businesses, it has been a topic of this committee. I've got my Zoom thing here in the way, but I just highlighted kind of that important piece that's a distinction. One thing under Act 181 was that accessory on-farm businesses were put on a party in the Act 250 permitting process with the municipal side of government, right? So there was a number of different things that happened in Act 181 that helped align those systems. Accessory on-farm business is one of those things. We didn't have accessory on-farm business as a specific exemption or call out in Act 250 prior to Act 181. Now we do. One of the differences, however, was this language that I've highlighted below, which was for the hosting of events and farm stays, was not included on the Act 250 side of the house. I mentioned the wood products manufacturer report. That was one of the other things, studies that came out of Act 181. As you can see here, and I discussed before, we're focusing on how can we make that better for this particular sector, particularly with a focus on the minor permit process, how that works, and any shortcomings or challenges that we need to address. I put a slide in here in terms of kind of our overall enforcement process and some of the tools that we have at our disposal. I was hoping I might be able to have our general counsel on today with me. She wasn't available, unfortunately. But I did serve the board for several years as associate general counsel, and did utilize these tools in that role as well. So just kind of in terms of how our process works, it's a complaint driven process, right? So if we get a complaint about a particular property, we will investigate that complaint. We have 2 enforcement officers. They do their due diligence on complaints that they receive. They will do desktop reviews where and when appropriate. But oftentimes and I think is mostly as a matter of course, they will do site visits to check in on the property. We do have the authority to request an access order, but in all of my time with the board, roughly 10 years or so now in the 2 different roles, I have not seen us needing to request an access order. Generally, it's been a process whereby the compliance officers are able to have that discussion with the landowner, reach out, say what time, when can we meet, and then they go on to the property and review things. Sometimes they can do some of that again, as I said, as a starting point, as a desktop review, giving a little bit of a sniff test, and certainly drive-bys as well to see what they can see from the road. And then kind of the next step, if it's met some of those thresholds, they're looking at a notice of alleged violation. This is a letter Can sound kind of scary, the way that it's the way that it's phrased. That's how it is in the statute. But essentially these are letters that say, hey, we think there's a reason why that there's a compliance issue on this or that property. That's kind of in two categories. One, you should have had a permit and you didn't get one, or you have a permit and you're not following the conditions of that permit. So those are kind of the two main categories that we look at in terms of enforcement. And they'll explicitly outline why they see enforcement issues or compliance issues at that particular property. The landowner will receive that and have an opportunity to discuss that with our team. Before those go out, there's an attorney assigned to the matter, and they have discussions with our attorneys. We have three attorneys. They're assigned to those matters, and again, review the facts and see if it's necessary to move to that next step. Oftentimes, those notices of alleged violations will also have compliance directives that can be go to the district office and get start your permit application process. And would allow that process to play out. Or it can be, clean up this, stop doing this, et cetera, those types of things. So there's certain compliance directives in there.
So what's the average length of time for the permitting process?
For the permitting process, I should know this right off the top of my head. I say somewhere in the range of six months, but it really depends on the process and the type of application. So an administrative amendment. So if those apply when you already have a permit and you're changing something to that and it's not having a substantial impact, those can go very quickly within a matter of a couple of days. If you're going through the minor process, again, there's a 30-day notice period. So you're talking a couple of months probably for that process. On the major hearing process, which again are relatively far and few between, those can go much longer, more in the year range, something in that range. So again, it depends on the facts and the situation for any given project. But going back to that kind of first slide, we've got 33 different criteria that our commissions are required to evaluate, and they need to make affirmative findings on each and every one of those criteria. Not every criteria necessarily applies to each and every project, but the commissions have to evaluate them. And so that's a fairly substantial charge, and we take that seriously, and it does take some time to evaluate that. The process certainly goes quicker if individuals have their ducks in a row, and that can take a little bit of time, energy, effort, and resources. We understand that, but it does help on any of that pre-work can really help on the permitting side, from my perspective.
What can you talk about the subject property that we have brought you in?
I'd really rather not talk about specifics on any given
Should they just tear the barn? Should they just tear the barn down and just put a tent up every weekly or whatever, and then they'd be in compliance?
So in general, when a project is and again I'm talking generally, but when construction improvements have been made for a commercial purpose, that's when a permit is required and jurisdiction attaches. But in terms of any specific case, I would recommend that folks, one, talk to their work, if it's in the enforcement complex and there's an investigation, work closely with the enforcement officer. They're wanting to help people through the process and get that completed and get compliance. It's important for us to ensure equity in terms of how we evaluate any compliance issues and do it even-handedly. I think the team works very hard at doing that.
Did you folks do a site visit?
They can do it. Yeah, they can do site visits.
What did you do on that property, or are you allowed to say that?
I have not been involved directly in that particular matter, and again, I don't want to talk about specifics on a particular project, not to be difficult on it or anything, but I'm happy to go through the kind of the general piece of how the operations work.
So Peter, I thank you for your presentation. Be honest, I voted against creating the board when we did that last year. We've gone from what was one full-time person to 5, which cost some money. Was there a complaint? Can you say that much?
Yes, so anytime our investigations again are complaint driven.
Okay, so we know based on that there had to have been somebody that complained. And to the chair's point, I'm not clear why we can't talk about, we're trying to fashion a solution in statute for this situation. And I'm wondering whether the district commission coordinator ever went to the site. And I don't understand why we can't find that out.
Yeah, I don't know. I don't know the district coordinator did, or if the enforcement officer did. And didn't have time to look into that on this particular matter, but as a matter of practice, that generally does happen, and there's no reason that if someone receives a noticeable ledge violation that they can't have that conversation. They should have that conversation with the enforcement officer and say, hey, I'd like to bring you to the property, or I'd like to show you what we've done here and how we see the issues on this, and want to look at a solution. There's no reason that somebody couldn't do that.
But there was a JO issue, jurisdictional opinion issue.
I believe so, but I heard that, but I have not looked at the specifics of that piece of the matter. And apologies, I don't have the general counsel online.
Based on your map, it looks like this is in District 2. I mean, we know where it is, so we're not keeping that confidential for any particular reason.
Yeah.
And do you know whether the location in question is in a tier 1, 1A, 2, or 3 geographical area?
I do not, but I can tell you this. The
guess
right now is
tier
tier 2, right?
Yeah.
Because meaning that it's status quo. It's the current situation.
Mhm.
Based on acreage and depending on what the project is, if it's housing or whatever. But that's where the state is right now. The board is still taking in those, and will be doing this early this fall, late summer. We'll be taking in those plans and the maps from the regional planning commissions to start designating those areas. So it's kind of, some of those slides is really a preview of what will be happening in the state. But it's a ground up process. The RPCs are reaching out with municipalities and their constituents there to help build and construct those maps. Then they come to the board, and the board if checks off if they've met all the statutory requirements, and will approve areas based on that.
Do you know whether or how many criteria there were in the original Act 250? We're talking the early 70s when that first went into play. And we're at 33 different criteria right now?
Yeah, so it's 10 criteria, but we like to more accurately say 33 sub-criteria, because when you take them apart, it is 33 different pieces that the commissions need to make positive findings on. The evolution of that, it's amazing how striking it is between the 1970 version that was on one piece of paper, and you can see the 10 criteria there, and the version that we have now in our statute book. It's amazing the lack of change between those. I think what it really is that it's been subsectioned, so that there's a lot more pieces to it. Although with one caveat, I guess, criterion 9 probably has a lot more in it. It's been sort of an area where different policy choices or whatnot have been added into the statute.
And one of the criticisms you hear quite often with any sort of Act 250 activity is the amount of time it takes to get a solution. And with 33, call them what you will, conditions, it's no wonder that it takes, you mentioned it could take 6 months, could take longer. Each day that goes by gets more costly for people that are involved.
And I think the story to be told is how many people I'm in this world, I'm in this business, I've been involved with a lot of development, and there's been no one. And speaking from person, I should probably do this, but I'm going to on this one time. Nobody's ever gone through Act 250 and said, "Oh boy, I'm going to do that again." No, it is not a pleasure. It is not a pleasant experience. It's avoided at all costs, and I see your 300 to 400, but there's probably 1,000 more that just don't do it. It's probably more than that. I mean, if you can avoid Act 250, you do. So in the sense of protecting growth, it does that just because people just don't want to do it. There's nothing good about it. Well, we're hoping to get probably more from you, but I don't know that we are today. I'm out of the committee, ask our final questions, and we're probably gonna try to craft something that is going to force more conversation. And I guess now where I was thinking that we might find a compromise, I think now we're just going to try to hammer something through and then we'll see where it goes.
How much of this is public record, and at what point does it, if it is, does it become public record?
In terms of investigations, yeah, I mean, there are some protections from some of those items. And yeah, I mean, so for instance, if there's a noticeable alleged violation that has been issued, that is certainly a public record. Certainly find that. Or jurisdictional opinions, all of those are on our database. You can find those as well.
Yeah, I mean, absent more specific information, it would be hard for us to figure out how to craft something that addresses, if the barn's too big, or if it was, I don't know how. It's hard to imagine that we could fix the problem unless we know what the problem is, and we don't know what the problem is right now. Do you know if the assurance of discontinuance was ever offered to the landowners?
Yeah, so that's I don't know in that specific matter, but that is that's generally I would say, and again, don't quote me on this, but I would say probably 95% of our matters go through that settlement agreement process rather than a more contested matter. As you can see, the administrative order is another piece. The other option is a civil citation, and I'll just say here too, because I didn't quite get through that piece of it, but assurance of discontinuance. So that's essentially after the NOAV phase. It's determined that there it's not just an alleged violation, there is a violation there. Then we would say, okay, here's our proposal for resolving that. Again, it would have compliance directives in there. It would oftentimes have a penalty associated with it. Landowner agrees, signs off, it becomes an official court order at that point. Another route that we take with some frequency as well is civil citations. And let me just backtrack one second. Sorry, on that assurance of discontinuance. The penalty amounts there are capped at $42,500, I think, per violation. That's the far end of those. They range anywhere from a couple hundred to that amount. the civil citation is another mechanism.
That
we've
that
used.
alone,
then,
right
yeah.
there, sorry to interrupt, but that alone right there is just ridiculous. And it just shows you how much stifling of anything, the thought of a fine for $42,500 is enough to just say, okay, no, I guess probably no, not gonna do that. That's just ridiculous stuff. But anyways, I apologize. Just
I appreciate your approach. I'll just, or your perspective. I'll just say that the Act 250 covers everything from, large ski operations to very small operations. And you could have something with severe environmental harm on a matter, to something that is relatively, minor violation of a permit. So we just have that, range within the statute. But point taken, understand where you're coming from on that. I just wanted to give the committee kind of the range there. On the civil citations, our range is 1 to 3,000. We have a baked in, actually, this goes for both assurance of discontinuance and civil citations, a baked in waiver amount that reduces that initial amount by, I think, again, don't quote me, but 25% reduction if it's agreed upon by the respondent at that time. That would not be applicable if somebody was going through the administrative order route. The last tool that we've got there is emergency. So that's if there's substantial harm and that is used with relative infrequency.
So there could be kind of an in-between of the notice of violation and assurance of discontinuance, where the notice of violation, the investigation hasn't been completed yet. Once it is completed, then so the letter sent first that there may be, then an investigation is done. After the investigation is done, then
Sorry, guys,
That's
just
right.
for
Yeah,
a second there.
I'm just trying.
So certainly preliminary investigation, and is really ongoing, and that's one of the reasons that I just don't want to talk about specific matters, because there's changing facts that occur, right, in the process. So that could be desktop review, that could be site visit, that could be videos that are sent from neighbors, it could be, any number of different pieces of evidence that are brought into the enforcement officer. They take all that, they assess that, they bring that to our attorneys, and they say, okay, is this an alleged violation? Is there one of those two things, either the violation of a permit condition or not having a permit where one should have been? They make that assessment, then they say, okay, let's send a letter of notice of alleged violation. We think we've got enough here to be able to send that out. That might change some of those. They get facts back from the landowner at that point. Maybe they have a follow-up site visit. They learn more about that. And some of those alleged violations, then the case is closed and there's no more on that particular matter. If it keeps moving forward, then we have these other options, the AOD, the administrative order, civil citation.
I hope you're not taking any of this personally, because I
No,
wasn't
if I
sure.
did, I'd be, yeah.
At least for me, it wasn't directed that way. It's just,
No, and I hear,
it's frustrating for those of us that aren't deeply involved in it. Do you know how many of the 5 are attorneys that are on the LURB?
we have one attorney on the land use review board. Yeah, one attorney, 3 planners, and 1 engineer.
You might not know the answer to this, but so I'm the prosecutor. I prosecute a case, someone commits a crime, it's a crime when it happens. Legislature comes by and they repeal it. Still a crime when it happens.
Yeah.
And I'm still going to prosecute it. Is that a similar situation with these sorts of violations where you'd still have a penalty even if the law changed after the violation occurred?
Yes,
typically what happens.
so the board, yes, the board, it is at the law at the time, unless the
Yeah.
legislature has a retroactive, application of a particular change in law.
Yeah.
So you're correct about that.
Obviously, you can always, there's always discretion on whether.
And then there's discretion in terms of whether the board enforces one or another. If there's a change in law that might influence it, it might not.
Right.
So yes.
Ready?
Thanks, Peter.
Okay,
Thanks for coming.
now you got beat up a little. I appreciate the information. It helps. For me to know the process.
Mhm.
There were some questions on the process, as well. And, I would echo, Senator Collmore's, it's not personal, we're just trying to solve a situation.
Yeah, and I appreciate that. I'm certainly not trying to be obstructionist on the particular matter or anything like that. But just want to try to keep things as even-handed and straightforward for everyone. But I would just end with, any particular matters or individuals. I hope that they feel that they can work with and reach out to our team to get resolution of any matter that there is. I think our team works really hard to assess cases and make sure that they meet the letter of the law and do so in a reasonable way. Thank you.
Thank you.
Again, for the
Thank you.
opportunity.
Okay.
Appreciate you coming in and for,
You're most welcome.
okay.
Okay, committee.
So 484, which is what we're talking about, license for Bill. I did send Michael O'Grady a request yesterday based on my conversation, our conversation with Secretary Moore and I'll Jackie Folsom to tighten the potential exemption to just the Rutland County Agricultural Society, Inc. And it would take the impact fee off and the completion of the offset project. Secretary Moore indicated that was something she could get behind, and so I asked Michael to redraft the amendment that he sent, and we could stick it in next week.
Yep, I want to do that. I want to, well, you're driving the ship. Now I want to fight.
Yeah. Yeah.
It's frustrating.
The answer to my question, though, makes me think that regardless of what we do, if they really want to get these guys, then they're going to do it because it doesn't change it. We change it now.
Right. Might change it for others.
We'll change for others later on down the road, maybe, but
The fact that we can't even talk about it is frustrating.
well,
There's facts in the case.
I've been there.
Right.
I'm not going to talk about an ongoing investigation,
Right.
especially since he's not involved.
Right. But you can talk about the facts of what's been. I get it.
Yeah.
It's comfortable. It's more comfortable not to. I get that.
Well, it's not. Having been in that situation when I know what's going on and I'm being asked and I want to tell somebody, don't worry, I have to tell them I can't, or, I can't tell them because they're going to head for the hills. But I mean, I'm not in that,
Yeah.
in that whole realm. It's a whole different.
And that's I guess,
Yeah.
another, to your point, that's another, they may be trying to give them some deference this year, but to your point, Senator Ingalls, I mean, I think we need to figure out a change.
And maybe we want to table it for now because they are okay and try to come up with something next year. Something more comprehensive, make it a lot like what we've done with S-124, make it a piece of our legislation and put some thoughtful time into it and to maybe some more of these facts have come out to where we can try to find the common ground, divide in it.
I wish I had the.
No, I get it. And I guess.
Well, that would be helpful if we had that at that
Yeah.
time and you could say, hey, here's where it is.
Just bring it. Here's what we got from them. Here's our
I
check.
apologize.
No,
Yeah.
that's fine. That's fine.
Yeah, the only thing we know right now that there was a complaint.
Yeah.
That was the only thing that Peter could tell us.
If, we don't even know where in the process of those steps.
Yeah.
We
Well,
are.
the JO was the judicial or jurisdictional opinion was issued. We know
I
that.
think that was from earlier.
We do.
Yeah. Because I looked up an article on it and it said it's 6 years ago or something that the JO was issued.
Mhm.
Yeah. So, I mean, the Valen Farm people, if they come in here to stack and stuff, this is what's going on. I feel like we're comfortable. But
Does that mean they've been in violation for 6 years?
I don't think so, because Act 181 just passed last year.
Yeah.
So I don't know if this is a new thing or what. And that's why I'm a lawyer. I want I want files. Look, I'm not actually don't want a piece of paper. I want electronics.
But it'd be one thing
Yeah.
if they called the guy and said, look, if you only have 3 of these instead of 5, we'll back up. That would be good information for us to know.
Yeah.
And I guess that's why I was trying to find out. Okay, they sent him a notice.
Yeah.
Did they find violations? Because he didn't. Because once they find
Yeah.
violations, my understanding, the next step is can we negotiate something? And I don't think that step has happened. I know that step hasn't. Otherwise, I don't.
Was there even a site visit? We don't even know. if
Yeah.
Site visit.
Well,
Yeah,
I don't.
but according to him, they have to do a site visit, but
They could do you call it a table.
yes, that's it.
Yeah,
Yeah,
yeah.
and that's a good point. Because at the beginning, I thought that, okay, they did it because he said they call them, they make an appointment, they come and.
So they can come without doing that too. And
Yeah.
Mr. Morel, to my knowledge, doesn't know whether they've ever been.
Yeah. No,
Or
you're
when.
right.
You're right. And he was kind of giving this is the ideal way that it should go.
Yeah.
It's not necessarily that's
Yeah.
how it's done.
Yeah.
Yeah. And this is just for my knowledge. I know the ideal way that the cops should be doing stuff, and then how the case is going to.
You start talking about a $42,500 fine.
I was gonna bring that.
I don't care who you are.
Yeah, and if
I
that's in
get
the
it.
letter, you're right.
Right.
Yeah.
Yeah.
I get it, you know, and it's meant to be that way. And as he said, yeah, and as he said,
So-
it's a little scary. Well,
Yeah.
no kidding.
I mean, let's be honest, that the whole Act 250, as I remember it, began with a ski area that was openly just throwing refuge and stuff out the windows and had no shame about it. And it eventually made it was basically a point source, a discharge into I mean, they literally didn't. And so, something had to be done. And I think everybody agreed at the time when it went in that, and I didn't realize there were 10 original criteria. I find that even a lot, but to get to 33, it's no wonder it takes them forever to come up with a thing. Now there's 5 of them working on it. So maybe it'll be a little more speedy, but, it's grown into this unbelievable monster.
And it just got, with 181, it's gotten out of hand as far as I'm concerned.
So-
It's just gotten ridiculous. They've gotten into, well, we don't regulate agriculture, except you do. You do regulate agriculture, but
The other side of that, I can sort of understand it, is if you had 10 acres and you were growing corn, so now you're a farm, but on the other 10 acres, you put up a huge building and
Yeah,
charge
yeah.
admission. I mean,
But I think it
You
gets
have to
down
sort of
to,
balance
it
it.
gets down to what the balance of a farm is.
Yeah, I know.
You know, with 51% and all of that,
Yeah.
but I think we're at this point in Senator Major and committee. I don't know what we can do about that. Here's what I don't know. I don't want to make a decision based on anger. That's not anger. So I don't want to make a decision based on that. I want to be a thoughtful approach and try to find a solution And if your folks are good for right now, and we can find out more facts, and we keep this from happening some more, because I do think it's an injustice. I'll put that out there. I do. I think it's an overreach. I think it's an injustice, and I'd like to, at some point in time, because they're not going to fine us $42,500. But they can find other people. But I think that we should find a way to wedge in there and put some cracks in this thing to make sure that more people aren't being harmed, because I do think it's an injustice. I don't put it out there. I do.
To your point, I think everyone's point, I think we're a little bit flying blind right now.
Yeah.
This particular, we don't know all the facts. And so we can't make an informed decision as far as that, or put out informed legislation. So.
No, and you're right. And that's what I really had kind of said at the chairs meeting the other night when they asked me, okay, well, where are you with this? And I said, well, we're just trying to put a bill out that makes sense. And just not to put something in. We want to have it make sense. I don't know if that we've got enough information to be able to put a bill in that makes sense.
Yeah, I agree with that 400%.
Well, take the weekend, think about it, I guess, no.
Okay. And you're gonna get the language on the fairs?
Yeah, we'll have it Tuesday, I'm sure.
Okay.
The fair, not fairs.
Right, fair, or,
I know you said something, sure, about working on 67 on
Monday, Tuesday.
Tuesday.
Yeah, we have it
Yeah.
on for Tuesday,
All right.
and then we can, we'll have Michael O'Grady come in and just go down to that one more time, see if we
Yeah.
want to make any changes, think we want to vote it out, see if we want to hang it back a little.
There's appropriations in that too, isn't there?
There might be, but,
Pretty sure.
yeah, there probably is, but if we pass it, then it'll sit there and we'll go from there, right?
Yeah.
So, I would say by the way that we were, funded, if there was appropriation, it probably stood just as much chance to pass it now than it would earlier.
I think if I remember it, we tried, I think it was 1.2 that's in there. Million. We were trying to get back the USDA stuff that went away.
Right, and we did that. We got $1 million of that
Yeah.
on the farm to table, or farm to school.
That's right, yeah.
Farm to school, so we got $1 million on that.
But the security fund went to just 1 million. I
1
think,
million.
Yeah.
So we have that coming
That
back.
was shot high.
Well, it is what it is. This is what we are, I guess the security fund has been going well. I can't remember if it's been passed out or what it's been. They've added forestry to that. We're gonna have to make a decision as far as what we want when we see that. And if we can't agree, we'll just go to a committee of conference. Because if it go, here's where it is. If they've added forestry to it, we lose control of the bill again.
Wasn't there also an amendment suggested that would say if you get money from
Yeah.
any other source?
Yeah, that's on the floor today, and
Oh.
actually, did we have any conversations with anyone? Okay. We're gonna have to, between second and third reading, maybe put an amendment on that.
Yeah.
Okay.
Yep.
They put it, and it came in on the floor, it didn't come in on the committee on that, so let's be aware of that when that gets reported out today, we will say that we're gonna put an, amendment on that. Yeah.
Yes. Hey, Amber.
Hello again.
I will apologize for my demeanor today. I was
No, I share your frustration.
very frustrated with that.
I got you. All right.
I don't think we were rude to Peter.
No,
Yeah, and I think he understood.
Yeah.
I mean,
I give him a lot of credit for coming into the Lions den in one way.
well,
Had to have
it's
known.
not going done. You gotta answer for what you do.
True.
So. Okay, so we're rambling on. Anything else that anybody would like to bring up?
That's fine.
No, thank you for your stuff today. It's very helpful, to understand that.
Yeah. When you said penalty, I was like, a change.
Okay.